There are moments in American history where you can almost feel the tectonic plates of the Constitution shift beneath your feet. We read about them in textbooks, the landmark decisions that redefine the relationship between the government and the people, the ones that law students will dissect for generations. But every once in a while, you're actually living through one. You wake up, go about your day, and somewhere in the background, 9 people in black robes have just rewritten the rules of the game. And that's exactly what happened just a few days ago, with a ruling that, frankly, hasn't gotten the widespread gut punch attention it deserves because the news cycle is so chaotic. We just witnessed the Supreme Court, in a stark 6-3 decision, effectively hand the keys to the kingdom over to any future occupant of the White House when it comes to the power to deport people. They have essentially unlocked a door that we, as a nation of immigrants and laws, deliberately kept locked for centuries. And my question to you, and I really need you to think about this and drop a comment, is this. If the president now has what appears to be limitless authority to decide who stays and who goes, what stops that power from being used against anyone the administration simply disagrees with? Seriously, I want you to type yes in the comments if you believe there are any real checks left, or no if you think we've just entered a whole new ball game where your legal status could vanish overnight based on a tweet. I'm going to break this down for you in a way that connects the dots. Not just the legal jargon, but the real-world airport lobby, ICE raid, knock on your door at 5 a.m. reality of what this actually means. Stick with me, because this is one of those situations where the fine print is going to dictate the future of millions of people living in the shadows, and, frankly, some people living in plain sight. Let's rewind for a second and look at the stage this was set on, because you can't understand the bomb that went off without understanding the fuse that was lit. For the better part of the last year, the second Trump administration has been laser-focused on one thing: fulfilling the promise of the largest deportation operation in American history. We're not just talking about the numbers at the border, we're talking about the interior, the heartland. We saw the deployment of ICE in ways that felt more militarized, the involvement of other federal agencies like the FBI and the DEA in immigration enforcement, which is a massive shift. We saw the passage of the One Big Beautiful Bill Act, pumping nearly $170 billion into this effort. But the courts, as they have for centuries, were supposed to be the backstop. They were the referees. If the executive branch swung too wide, a judge, appointed for life specifically to resist political pressure, was supposed to blow the whistle and say, "Hold on, that violates the law, that violates due process." And for a while, that's exactly what we saw happening. You had judges across the country pushing back. There was a particularly contentious battle playing out in Boston with a Biden-appointed judge named Brian Murphy. He was looking at a policy of deporting people to third countries, places they had no connection to, no ties, often with questionable safety records. He ruled that this process was violating due process, that people weren't getting a fair chance to say, "Wait, if you send me there, I'll be tortured, I'll be killed." The administration was furious. They went to the Supreme Court, and even last year the court stepped in and told Judge Murphy, essentially, "You're overstepping, stand down," in a 6-3 order. But here's the crucial part, and I want you to really let this sink in. Even when the Supreme Court tells a lower court to stop, sometimes those lower court judges try to find a workaround. Judge Murphy tried to carve out exceptions for specific individuals, and the Supreme Court came back with a rare, scathing 7-2 follow-up order, essentially telling him he was defying them. It was an unusual move, almost unheard of, for the High Court to have to issue a second order just to say, "No, we really, really meant it." This was the first tremor. It signaled that the conservative supermajority was not in the mood for judicial roadblocks when it came to the executive's deportation machine. Then you had the TPS cases, the temporary protected status battles, which were absolutely critical to understanding the mindset of the court. TPS is a program designed for people from countries in chaos, war, environmental disaster, you name it. It allows them to live and work here legally, temporarily. The administration wanted to end it for hundreds of thousands of people from Venezuela, Haiti, Syria. They argued that the conditions that warranted the protection no longer existed. But lower courts looked at countries like Syria, which was literally in the middle of an active war zone, with airstrikes hitting neighborhoods, and said, "Are you kidding me? You can't send people back to that." There were declarations from Syrian nationals describing their families' homes being bombed shortly after the administration revoked their status. It was stark, human evidence. And yet, on the shadow docket, which is this emergency side of the Supreme Court that operates without full arguments or detailed opinions, the court repeatedly sided with the administration, allowing them to strip protections from Venezuelans while the cases were still being fought. The SCOTUS blog analysis points out something that should terrify you. These temporary orders have permanent consequences. People were deported. They were sent back to dangerous situations while their legal cases were still technically alive. The court's message was becoming clearer by the day. The executive's urgency to deport outweighs the individual's right to a complete legal process. Now, fast forward to this latest ruling. It's important to understand that this wasn't a decision made in a vacuum. It was the culmination of all those smaller battles. The court had already signaled its hand in the Venezuelan TPS cases. It had already shown its willingness to back the administration in the third country deportation fights. The final piece of the puzzle was a pair of cases involving Haiti and Syria, where the administration was again seeking to end protections. In a lower court, Judge Ana Reyes in Washington, D.C., had issued a blistering ruling blocking the termination for Haitians. She went so far as to say that the administration's actions were substantially likely driven by hostility to non-white immigrants. She pointed to public statements by officials calling immigrants killers and leeches as evidence of a preordained biased outcome. It was a powerful, fact-based rebuke. But when it got to the Supreme Court, the 6-3 conservative majority wasn't interested in the facts on the ground in Haiti, or the social media posts, or the intent. They were interested in a principle, a much broader, more dangerous principle, that the political branches, specifically the executive, have virtually unreviewable authority over immigration. Think about the language the administration's lawyers used. Solicitor General D. John Sauer argued that lower courts were engaging in persistent disregard of the Supreme Court's authority. They painted a picture of a rogue judiciary, trying to micromanage foreign policy and national security decisions that should be left to the president. And in this 6-3 ruling, the majority bought it. They didn't just say the administration could deport the specific Haitians or Syrians in question. They didn't just defer on a technicality. They established a framework that essentially says that when the president, acting through the Department of Homeland Security, decides that a group of people should no longer be here, the courts have a very limited, almost non-existent role in second-guessing that decision. They effectively ruled that due process, the Fifth Amendment right that says no person shall be deprived of life, liberty, or property without due process of law, takes a backseat to the executive's plenary power over immigration. And that right there is the earthquake. That is the unlimited deportation power. Because what is due process? It's the right to a hearing. It's the right to present evidence. It's the right to an immigration judge who actually looks at your case and says, you have a valid fear of torture, or you've been here for 20 years with a clean record and U.S. citizen children. This ruling, in its broadest interpretation, says that those procedural safeguards can be swept aside if the executive deems it necessary. It doesn't even have to be an act of Congress. It can be a policy memo, a tweet, a press release. The president now has the judicial blessing to designate entire nationalities, entire groups, for expedited removal without the courts being able to step in and say, wait a minute, let's check the facts on the ground in that country. I want to take you inside the mind of an immigration officer right now, because that's where the rubber meets the road. They're not sitting in a marble courthouse reading Supreme Court opinions. They're on the front lines. And what this ruling tells them is that their authority has been supercharged. Before, if they wanted to detain and deport someone, they had to navigate a web of potential legal challenges. The person might have a TPS application pending. They might have an asylum case. They might have a U.S. citizen spouse. An officer had to at least be aware that if they screwed up, a judge could reverse it and the government could be held liable. Now, the signal from the highest court in the land is deference to the executive. The courts are getting out of the way. That emboldens enforcement in a way that's hard to overstate. It changes the psychology of the raid, the traffic stop, the workplace check. The fear of getting it wrong, of violating someone's rights, has been judicially minimized. Let me paint you a realistic scenario, and this is where the traveler part of my experience kicks in. Imagine you're a lawful permanent resident, a green card holder. You've been here for 30 years. You pay taxes. Your kids are American citizens. You made a mistake in your youth, a misdemeanor DUI 25 years ago. You travel abroad for a family funeral, a wedding. On your way back, you land at JFK or LAX. You go to the secondary inspection room. The CBP officer pulls up your record. Before this ruling, a good officer might look at that old DUI, see the decades of clean history, the family ties, and admit you. Maybe they issue a warning. But now, in this new environment, with the signal being deport first, ask questions never. That same officer has a different calculus. They can interpret that old DUI as making you removable. And thanks to the Supreme Court's deference, they know that even if you fight it, the courts are unlikely to stop your deportation while the case drags on. You could be put on a plane before your lawyer even gets to the courthouse. That's the new reality. That's the fear. And it's not just about people with criminal records. That's the trap a lot of folks fall into. They think, I'm a good person. I haven't done anything wrong. I have nothing to worry about. But history and human nature tells us that undesirable is a moving target. What defines a threat to public safety or contrary to the national interest is entirely up to the administration in power. Today, it might be someone with a DUI. Tomorrow, could it be someone who signed a political petition the president doesn't like? Could it be a journalist who wrote critical articles? Could it be a family who received public benefits during a tough time? This ruling hands the executive a blank check. The Due Process Clause wasn't written just to protect the popular. It was written to protect the unpopular, the minority, the person the majority wants to ship out. By stripping away the judicial check, the court has made everyone who isn't a citizen, and even some who are, vulnerable to the whims of the political wind. We saw hints of this coming in another Supreme Court case argued just weeks ago, Urias-Orellana versus Bondi, where the court unanimously ruled that courts must defer to immigration judges' factual findings on asylum. On the surface, that sounds neutral, even pro-immigration judge, but look deeper. It's about deference. It's about telling appellate courts to back off. When you combine that deference to the initial decision-maker with the new ruling that the executive's policies are largely immune from review, you've created a system where the initial decision, often made by an overburdened, politically pressured immigration judge or a CBP officer at the airport, is the only one that matters. And we've already seen reports that immigration judges are being instructed to grant asylum only in rare instances. So, the deck is stacked from the very beginning. The administration's argument, which clearly resonated with the 6 conservative justices, is that these are matters of national sovereignty. They argue that the president, as the chief executive, has the constitutional authority to control the borders and decide who can remain. They point to statutes like the 1798 Alien Enemies Act to show that this power has deep historical roots. And on paper, that sounds compelling. A country has to have the right to control its borders. But the rebuttal, which the 3 dissenting justices clearly understood, is that we are a nation of laws, not of men. The whole point of the Constitution is to create a system where even the sovereign is subject to legal constraints. The Immigration and Nationality Act is full of procedures, protections, and standards that Congress wrote. The executive isn't supposed to just ignore them because they're inconvenient. The majority's ruling essentially says that if the executive ignores them, too bad, so sad, the courts aren't going to stop it. Let's talk about the political ramifications, because this is where it gets really interesting and where the course correction you might be hearing about comes into play. There are Republicans in Congress, like Senator Ron Johnson of Wisconsin, who are starting to sweat. Why? Because they represent states where the economy depends on immigrant labor. Johnson pointed out that in Wisconsin, immigrants milk most of the dairy cows. Restaurant groups are panicking about losing their workforce. If the administration starts deporting everyone, including the people working in the fields, the kitchens, the construction sites, the economy in red states is going to take a massive hit. So you have this tension. On one side, you have hardline groups like the Mass Deportation Coalition, backed by the Heritage Foundation, pushing for Phase 2, which means going after everyone, not just violent criminals. On the other side, you have business interests, and some politicians saying, whoa, hold on, we need these people. This Supreme Court ruling gives the administration the legal green light to go full speed ahead with Phase 2. Whether they have the political will and the stomach for the economic fallout remains to be seen, but the legal handcuffs are off, and the human cost is already being tallied. We saw the tragic incidents in Minneapolis, where federal agents fatally shot 2 U.S. citizens during enforcement operations. These weren't immigrants, they were Americans, caught in the dragnet of an overly aggressive, unchecked enforcement machine. When you tell an agency they have broad power and limited judicial oversight, mistakes don't just happen, they become inevitable. The message to agents is move fast and break things, and the things in this case are human lives and families. The protests that erupted after those shootings are a sign of what's to come if this power is wielded indiscriminately. The country is at a crossroads. We have to decide if we are still a nation that believes in the principle that everyone, regardless of their paperwork, deserves a day in court, a fair hearing, a chance to tell their story. So, Back to my opening question. If the president now has what appears to be limitless authority to decide who stays and who goes, what stops that power from being used against anyone the administration simply disagrees with? The dissenting justices warned that this ruling would have staggering consequences. They saw it as an abdication of the judiciary's core function. And they're right. The checks and balances we learned about in civics class are only as strong as the people willing to enforce them. When the Supreme Court steps back and says, "This isn't our job anymore," the balance tips dangerously toward the executive. We're entering uncharted waters. The rule of law is supposed to protect the vulnerable from the powerful, but when the powerful control the interpretation of the law, the vulnerable are left exposed. This 6-3 ruling didn't just change deportation policy. It fundamentally altered the relationship between the citizen, the resident, and the state. It handed future presidents a weapon, and the only thing that will determine how often it's used is the political and public backlash that follows. Now, I want to hear from you in those comments. Do you feel safer knowing the executive has a freer hand, or do you feel more at risk? Let's get this conversation started.